A parent's nightmare is a situation where your daughter goes out one night and never comes back. Their grief is uncalculable.
The LA County District Attorney has just made a big decision regarding criminally charging singer David in connection with the murder of 14-year-old Celeste Rivas Hernandez. It was a shocking press conference where we learned never before heard details of this case and investigation, and where some of the questions we have had for the last 7 months have been answered. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Hey, real quick, before we go any further, I gotta tell you about this app that I think you're gonna love. It's our partner, Upside. So Upside gets you cash back. Yes, extra cash back on everyday purchases like gas, groceries, takeout. Here's what you do. You download Upside for free. You claim an offer at one of their 100,000 plus locations. You pay like normal with your card. You verify the purchase, and just like that, money back. So say I need to get gas or I want takeout one night. I'll search for Upside offers first. And after I spend, money appears in my app that I can transfer right into my bank account. Upside's frequent users, they earn an average of $254 back a year. So to start getting your cash back, click the link in the description or scan the QR code, but make sure to use our promo code SIDEBAR because you'll get an extra 25 cents bonus on every gallon on your first tank of gas. All right, huge day in David news. There was a big press conference that was held by the Los Angeles District Attorney's Office. I'm talking about LA District Attorney Nathan Hochman. This is in conjunction with the LAPD. In this room, they were flanked by a mugshot, a new mugshot of David, and a picture of Celeste Rivas Hernandez. We have finally learned whether David will be criminally charged and with what. And remember, this comes on the heels of what we reported last week, the arrest of the 21-year-old romantic homicide singer on suspicion of the murder of 14-year-old Celeste Rivas Hernandez. 7 months ago, her reported decomposed and dismembered body was found in the trunk of a car reportedly registered to the singer. And it was confusing because he was arrested but not charged last week. And we thought that's strange because our reporting was, and we saw this from TMZ and other outlets, that a grand jury had reportedly been hearing evidence for quite some time in this case when the arrest came down. So why was he arrested and not charged? And we speculated and wondered, did the grand jury not believe there was enough evidence to charge him with a crime? Maybe it wasn't a grand jury with the power to indict, maybe just to hear evidence and lock in testimony. Maybe they were still hearing evidence when the arrest came down. And that's why you saw, and we heard this a little bit from TMZ too, whether or not the LAPD and the DA, maybe their offices were not on the same page. You go to this press conference, that was not the case. I'll get to it in a second. So remember what also happened last week. The LAPD, the PIO, released a statement. Detectives from Los Angeles Police Department Robbery Homicide Division have arrested David Burke, a 21-year-old resident of Los Angeles, for the murder of Celeste Rivas. Burke is being held without bail. The case will be presented to the District Attorney's Office on Monday for filing consideration. That's today. Now, this also came in from the LA County District Attorney's Office last week. Greg Reisling. Good evening. Our office is aware of the arrest of David Anthony Burke by the Los Angeles Police Department. The case is expected to be presented to the Major Crimes Division, at which point prosecutors will review the facts and evidence to determine whether there is sufficient evidence to file charges. At this time, additional information is not available. We will share an update on Monday once a filing decision has been made. So you hear that language and you wonder, again, were they on the same page? Now, LAPD Captain Scott Williams told NBC last week regarding David's arrest at this home in the Hollywood Hills, "We did the best we can to keep tabs on him, but once we developed probable cause to arrest him for murder, then we were on him pretty diligently." And he told the California Post they had a probable cause warrant with them when they made the arrest. And there were photos of armed police outside the residence making the arrest. Per reporting from the California Post, David appeared to be in handcuffs. He was led away. A neighbor told the outlet there were so many cops. There was apparently an officer on a loudspeaker shouting surrender. It was a big scene. We also heard from David's attorneys. So Blair Burke, Marilyn Benarski, and Regina Peter, they released a statement saying, "Let us be clear, the actual evidence in this case will show that David Burke did not murder Celeste Rivas Hernandez, and he was not the cause of her death. There has been no indictment returned by any grand jury in this case and no criminal complaint filed," although you'll hear Nathan Hochman maybe suggest otherwise about a criminal complaint. "David has only been detained under suspicion. We will vigorously defend David's innocence." Now, again, this was from last week. We got to talk about what happened today. Okay? By the way, before I even get into today, TMZ reported that their source told them that the ME, the medical examiner's office, determined Celeste's manner of death to be homicide. Okay? Takes us now to today. Los Angeles District Attorney Nathan Hochman held a press conference alongside members of the LAPD, including Scott Williams, who I mentioned before, even indicated Beth Silverman will be the lead prosecutor on this case, which is interesting because we had previously reported she was the one who was apparently presenting evidence to this grand jury. She's a career prosecutor, particularly in homicide cases. And this was the moment, after 7 months, when Nathan Hochman announced the charging decision for David Anthony Burke. David.
Today, I am announcing the charges against David Anthony Burke, the musician known as David, spelled D4VD, in connection with the brutal and horrific murder of Celeste, a 14-year-old at that time. These charges include the most serious charges that a DA's office can bring. That is first-degree murder with special circumstances. The special circumstances being lying in wait, committing this crime for financial gain, or murdering a witness in an investigation. These special circumstances carry with it, along with the first-degree murder charge, a maximum sentence of life without the possibility of parole or the death penalty. The determination on whether or not the district attorney's office will seek the death penalty will be made at a later time. Before I get into the actual charges, and there are additional charges against Mr. Burke, including continuous sexual acts, lewd and lascivious sexual acts with an individual under 14 years old, and mutilating a human remains of a body. Before I get into the description of these charges and their seriousness, I want to look at this as a parent. I am a parent of 3 children, and a parent's nightmare is a situation where your daughter goes out one night and never comes back. As we will show in a court of law, and what I also want to make sure about that the understanding of these charges is clear, is my description of these charges is not evidence that we are going to present in court. These charges, in fact, will not be evidence in the court. Evidence will be the witness testimony, the documents, and different types of admissible testimony that we will admit into court in the prosecution, and if it leads to the eventual trial of Mr. Burke, to convince a jury of 12 people beyond a reasonable doubt that each and every one of these charges is true, as well as the special allegations and circumstances that have been alleged.
Okay, first of all, we suspected that David would be charged with murder after that was what he was arrested for, and in other court documents that came out a couple months ago, we know that he was being investigated for murder. But first-degree murder with special circumstances? Lying in wait to kill? Murdering a witness as part of an investigation? Murdering for financial gain? And now facing the possibility of the death penalty, even though it's my understanding there is a moratorium on executions in California. That is a huge deal. And in a minute, we're going to get to the reasons the DA believes the evidence purportedly shows that. But what you're seeing are different alternative theories on how to prove the murder charge here. And clearly, they believe David is at the center, that David is the one responsible. Now, to be clear, he is innocent until proven guilty, and we don't know the exact evidence that the prosecution is going to produce. But also, the sex charges? This is something we have talked about before. Steve Fisher, the private investigator who has been representing the owner of the property where David had reportedly been staying at in the Hollywood Hills, reportedly near where the Tesla was found, he has been saying for months that David could already be charged with sex crimes. That aside from the alleged murder, that there's evidence that David was allegedly having a relationship with a minor. And you heard Nathan Hochman say continuous, meaning more than one time over a period of time. And you're going to hear later when Hochman talks about digital evidence. Are we suggesting here text messages showing this relationship? Photos? Videos? Witness statements of those around the two, maybe? And I'll tell you what, this is the part of the press conference where Hochman talks more about the alleged crimes, and he goes into the different theories. Again, lying in wait, murdering a witness. Take a look.
On April 23rd, 2025, has been alleged by the complaint, Celeste, a 14-year-old at that time, went to Mr. Burke's house in the Hollywood Hills. She was never heard from again. On September 8th, 2025, as alleged in the complaint, Miss Celeste remains, her dismembered and decomposed remains, were found in 2 bags inside of a front trunk of a car registered to Mr. Burke. Thereafter began an investigation. The investigation was to determine who killed, who murdered Celeste months and months before. That investigation was carried out in unison and in partnership between the LAPD's Robbery Homicide Division and the District Attorney's Office. At every point in the investigation, through the arrest and the filing of charges, the LAPD and the District Attorney's Office have worked in lockstep. There's been no disagreements amongst these entities in deciding how to proceed with this case, ultimately leading to these charges today. So what you have as well with these charges is that, again, there are 3 sets of charges that have been brought. The first-degree murder with special circumstances, and again, those special circumstances are lying in wait. That Celeste went to Mr. Burke's home on the night of April 23rd, 2025, as alleged in the complaint, at his invitation, and again, was not heard from again. The second is a special circumstance, being that this murder was committed for financial gain. As the evidence will show in court, the financial gain was for Mr. Burke to maintain his very lucrative musical career that Celeste was threatening on that particular night. The third charge, in addition to lying in wait and for financial gain, is murdering a witness to an investigation. In this particular case, as the evidence will come out in court, the witness to the investigation was Celeste. And the investigation was into the lewd and lascivious sexual acts committed by Mr. Burke that is the subject of count 2 of this complaint with Celeste while she was under 14 years old.
Wow. So it seems a fair interpretation would be she allegedly goes to this house, this property, that David, they're going to be saying allegedly lured her there, or got her there, invited her there. And either he allegedly wanted her there because he planned to kill her, again, if the allegations are true, these are the allegations put forward, but that she was what? Planning on going public or telling someone about their relationship? Planning to go to authorities about this relationship? I don't know. But that this was essentially going to risk his career. So he allegedly kills her to keep her quiet, make sure his album, his endorsements, his tour wouldn't be affected. I'm wondering if that's going to be the argument. I wonder if that's going to be the theory of the case. And I assume that's going to be the argument. Now, how will they prove that? How will they prove that intent based on the circumstances and timing of this alleged killing? Text messages, witness statements? We shall see. But again, different theories here. And remember, I just go back to this, and I don't know if this for sure, but during the grand jury, it was reported by certain outlets that this record executive had testified. I mean, again, allegedly, what do the people around David know? What were they told? What did they communicate to him about his career, about his finances? Just things I'm thinking about right now. And then we go into where Hochman talks about Celeste's family.
I had the chance to meet with some of the family members of Celeste, and their grief is uncalculable as to what happened to their daughter. What they have demanded, what we have assured them that the District Attorney's Office, working with LAPD, would give them is the proof beyond a reasonable doubt on who killed their daughter, on how their daughter was killed, when their daughter was killed, and bring that killer to justice. That killer that we have now charged is David Anthony Burke.
Now, at one point, Nathan Hochman brings on LAPD Chief of Police Jim McDonnell, who not only talks more about the investigation, but also addresses the frustration the public has had with law enforcement regarding this case and a lack of public comments or transparency.
Throughout the 7-month investigation, this department has faced criticism for how we handled the case and for our decision not to provide details. I want to be clear about something. My duty is not to fuel speculation, it's to deliver justice, and that requires patience and discipline on everybody's part. This investigation was driven by a single purpose: to secure justice for Celeste Rivas and for those who loved her. We had to be certain that nothing we did or said would ever jeopardize this case. Ms. Rivas was a reported runaway from Riverside County. During the course of our investigation, detectives learned that she had been involved in a sexual relationship with Mr. Burke when she was a minor and he was an adult. On April 23, 2025, Ms. Rivas arrived at Mr. Burke's home in the Hollywood Hills. That's the last time she was known to be alive. On September 8, 2025, Ms. Rivas's dismembered and badly decomposed body was discovered in the front trunk of Mr. Burke's impounded Tesla. From that moment forward, our investigators faced an extraordinary, difficult, and complex case. The condition of her remains delayed the medical examiner's ability to be able to determine cause of death. The substantial amount of time that passed between her death and the discovery meant that crucial evidence had degraded or disappeared. And as detectives worked to uncover the truth, they also had to sift through and debunk a great deal of false information circulating publicly. These challenges were real, and they required patience, precision, and an unwavering commitment to the facts. Despite these obstacles, and despite intense public pressure, our Robbery Homicide Division detectives remained steadfast in their duties. They recovered and analyzed a substantial amount of digital and forensic evidence. They stayed focused, disciplined, and committed to uncovering the truth. Their work, in close collaboration with the District Attorney's Office, has brought us to this moment today. I want to thank the District Attorney and his team, as always, for their partnership. This case demanded coordination, persistence, and a shared commitment to justice.
And that makes sense. He's not wrong. You don't want to say too much that could jeopardize a case, give a criminal defendant ammunition to say the investigation was tainted or the prosecution is tainted, or that you had blinders on and we're only looking at one person without looking at exculpatory evidence. But you also have more about cause of death, right? Which hasn't been publicly released because of a court order. The medical examiner's records have been sealed. In fact, Hochman took questions about a lot of things, and he took questions about this. And he talked about how details of the allegations regarding the special circumstances, they're going to be produced in court. He didn't talk so much about it, but he did talk a little bit more about the coroner's report.
So with respect to the coroner's report, we will be seeking quite quickly to provide an order to the court that now allows the coroner to release that report to the public.
So once that report is released, and we will see what the coroner's finding or conclusion is, that's going to be a piece of the puzzle. I mean, I hate to say this, but again, it's tough to think about cause of death and how you analyze that when you're dealing with reportedly dismembered and decomposed remains. So could they be able to determine, let's say, asphyxiation or poisoning or blunt force trauma or a gunshot wound? And I don't even want to think about this, but was the cause of death the alleged dismemberment? And by the way, you heard the defense attorney say he's not the cause of death. Is that because they have their own interpretation of what the cause of death could be? Is this going to be a battle of medical experts? Or are they going to point the finger at somebody else and say that person is the cause of Celeste's death? And Hochman was asked, why did it take so long to make an arrest here, given, again, the body was allegedly found in David's car, and you look at the state of Celeste?
I think the police chief got it right, that in a situation where you don't have an eyewitness account, or we can't point to a video that shows the killer killing someone, you have to go through the very rigorous and thorough investigation to look at all the digital and forensic evidence. You have to speak with witnesses, often who are cooperative and some who are not cooperative, in order to obtain all the information necessary to decide who did what, when, how, and what their mental state was at the time. That is what we've been doing over the last, between September 8th, roughly, and today when we bring these charges on April 20th. So again, it's a type of case that you want to make sure you get maximum information. And by the way, if there's anyone out there that has material information about this particular murder or any other actions taken by Mr. Burke, please come forward to the Los Angeles Police Department, come forward to the LA County DA's office, and report that information.
So it gives us an idea of the evidence, maybe lack of evidence. You talk about a smoking gun, that one thing. No, totality of the evidence, all of the evidence, not one thing. Some cooperative and non-cooperative witnesses. Is anyone working under an immunity agreement to provide testimony? We talked so much before about Neil Langston, David's purported friend, how he was arrested in Montana for allegedly failing to appear as a witness. Seemingly in this case, what was it, in front of the grand jury? TMZ had reported that he had only testified for 30 to 40 minutes. If that's the case, was he uncooperative? Is he a witness? I can't say for sure. Neil Langston did not come up today. Now, according to Hochman, the investigation is ongoing. They believe they have a strong case because of the totality of the evidence that was obtained by the LAPD robbery homicide unit. They talk about the work that the DA's office has done. They believe they can prove these charges, the special allegations, the special circumstances. And this is where Nathan Hochman discusses whether anyone else will be charged.
Is it possible that you will be arresting other people within his circle, and did he act alone in this death?
Again, with respect to whether or not there's any other individuals or we're going to take any other actions, you will know about them if we do, but at this point I'm not commenting.
Do you believe that you know how she was killed, beyond it being homicide? The actual cause of death?
The coroner's report will be released shortly. Because it is not currently released, I'm not going to be commenting
But
on it.
was it determined, not that, if you won't say what it was, but has it been determined how she was killed, beyond it being homicide?
The coroner has made a determination on how Celeste died, and at the point that the coroner's report becomes public, we'll be able to comment on it.
Was there a specific breakthrough last week? Is there physical evidence that ties David to this murder?
There is physical evidence and there is forensic and digital evidence that we intend to present in court to prove these charges beyond a reasonable doubt.
Only a couple more questions.
Yes.
Your investigation, and just to his question, are you able to tell us exactly what the smoking gun is? And also, if you can address the issue of his visit to Santa Barbara, and that, how does it connect with the murder?
So with respect to the actual details of the evidence we're going to be presenting in court, I'm not going to do that today. As far as the concept of a smoking gun, the smoking gun is the totality of the evidence that we're going to bring to prove any case, whether it's this case or any case, beyond a reasonable doubt.
Is there any evidence that you've used other underage girls that you investigated?
An investigation is ongoing. If information comes forward on any, with respect to any additional crimes, we will certainly investigate it.
One more question. One more.
There's been so much discussion about the difficulties in this case. The chief talked about it as well. What makes you confident you can prove these evidence?
What makes us confident is the totality of the evidence that has been obtained by the LAPD robbery homicide, by the work that the district attorney's office has done, that has led us to the point where we believe we can prove each and every one of these three charges and the special circumstances and the special allegation beyond a reasonable doubt.
So I guess it's possible someone else could be arrested or charged. I don't know, maybe if someone refuses to cooperate, refuses to provide testimony. We will continue to stay on top of this case wherever it will go. Thank you so much for joining us here on Sidebar. As always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, 11 p.m. Eastern, Monday through Friday. I'll see you next time, everybody. Bethany Israel, a married woman pregnant with her first child, she ended up having dinner with her brother and never came home again. What police say they discovered inside a house was so gruesome, so horrific, that it is difficult to imagine. Evidence pointed police straight to her brother Jack Ball, and for a moment, it looked like this case was headed toward a clear ending. But now, That ending is not so clear. We're going to break down the disturbing details and the latest legal twist with attorney Joe Richardson. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Now, real quick, there's something that we use here at Law and Crime that I think can actually be very useful to you, maybe add a layer of security to your life. So we partner with TruthFinder for the public record search services that we do here at Law and Crime. It saves us research time so we can focus on reporting crime and not the paperwork. But you can use TruthFinder too. Why? You type in a name, you can find addresses, you can find criminal history. There's a lot more. It's our go-to tool. It's our go-to tool for checks and one of the largest search services in the United States. And with a subscription, you can get unlimited confidential searches to check on new neighbors, vet people you meet online, maybe find somebody to reconnect with. You can even look up registered sex offenders in your area too, or even do a background search on yourself. But stay informed, stay safe, and check public records with TruthFinder now at truthfinder.com/LC Sidebar. Now, we tell a lot of stories on this show. Stories that end with a verdict, a sentence, a feeling that however horrific the crime was, the system finally turned a key, locked a door, we don't have to think about it again. It's over. But what happens when a guilty plea isn't the end? What happens when the door is maybe thought to have slammed shut, but instead it swings wide open into a whole new fight that adds a whole new layer of context and a whole new layer of uncertainty? That is what is happening right now concerning Bethany Israel, a 30-year-old teacher, coach, wife. She was expecting her first child, a son named Levi. In May of 2024, she went to her brother's house for a family dinner, and she never came home. So her mother, who was worried, went to check what was going on. And what she walked into was a literal slaughterhouse. What I'm about to get into is incredibly disturbing, okay? Fair warning. Police reports detail a bloody saw, a hatchet, and dismembered body parts. Later on in their search, investigators apparently found journals that led them right to their suspect, her own brother, Jack Ball, and also to a possible motive, because in those journals, police claim he wrote he was angry she was pregnant. And then you go to January 21st. This is after he's arrested, this is after he's charged, and Jack Ball stood in a Dakota County courtroom out in Minnesota and pleaded guilty to the premeditated first-degree murder of his sister Bethany and to the murder of her unborn child, so basically his nephew. Now, you would think that would be case closed, right? You would think that would be justice served, right? No. Because in that same moment that he pleaded guilty, his defense declared he's not criminally responsible, that despite his admission here, the law should not hold him legally accountable for these murders. So you have a guilty plea and a claim that he's not criminally responsible. How can both be true? What happens next? I'm going to get straight to the facts here. I'm going to start from the top. It's the evening of Thursday, May 23rd, 2024. Bethany Israel, who was about 4 months pregnant, heads over to her brother's house in Lakeville, Minnesota. According to the Dakota County Attorney's Office, she was going there for dinner. Now, hours pass. Her family can't get a hold of her. They are obviously worried. So at around 11 p.m., her mother drives over to Jack Ball's house, her son's house, right, to check on her daughter. And according to the criminal complaint, here's what happened next. The mom pulls up and sees Ball, quote, tear out of the house. She goes inside and immediately sees a large amount of blood. She calls 911. Police from the Lakeville Police Department, they respond. What they find inside, according to their reports that are detailed in the complaint, is horrific. In the kitchen, there is a large pool of blood. They find a bloody saw, hatchet, large bloody knives, and as they continue to move through the house, they see a knife on the living room floor near the staircase, and then they find several dismembered body parts. And while the scene is unfolding, police get another 911 call. This one's from a resident in Rosemount, that is a town a few miles away. This caller reports that someone was caught on the Ring doorbell camera placing what looked like a body part on the front step. Apparently, Ball was seen running away. Police seemingly find him. He's covered in blood. He's at a different location. Also has a potential self-inflicted wound to his neck. And then the filing says this, quote, upon searching the area, police found several dismembered body parts they believe to be those of victim 1. Yeah, it's bad. It's incriminating. He was arrested. He wasn't criminally responsible. Why? Because as the county attorney had said, Ball, quote, has asserted a defense of mental illness. And they are going to stand trial in late May of this year, 2026, where the state will litigate Ball's defense of mental illness. That's what we got to talk about. All right, so we're going to get to the why about that in just a minute, and I want to break down more of what we're seeing here. I want to bring on civil rights attorney Joe Richardson. Joe, thanks for taking the time to come back here on Sidebar.
Good to see you always, Jesse.
I got to say, I'm not surprised he pled guilty when you look at just the potential mountain of evidence. There's the scene. There's the idea of, witnessing him running away on the ring camera. He's found self-inflicted injury, bloody. Apparently, they search the area, find the sister's body parts. I don't even know what you would do as a defense attorney at a trial.
Pray. You know what I mean? So, yeah, I mean, and the letters that he wrote, and exactly, basically, there's a record that shows exactly why he did what he did between the film and the actual evidence that they found when they got there. They know what he did. They know how he did it. They can connect him to it. So from a defense standpoint, you would have to go to like a mentally ill defense. You'd have to. He presents a motive. He presents the what, the who, the where, the why, and the how, everything that you need for a case. So you'd have to go to a mental illness defense and hope to go down that road and have him considered differently than someone who really thought through on a first degree level, or maybe you go second degree because he was indicted of each, both first degree and second degree, and theoretically second degree might not bear as much in the way of punishment.
Talk to me about this, where he pleads guilty. It's not the end of the story, though. So here, right under the state, you plead guilty, but then you can also simultaneously say, no, we need a trial to determine whether or not he's criminally responsible due to mental illness, right? So, and by the way, for people at home who don't know this, walk us through how that works. I mean, am I understanding it correctly?
Yeah, I mean, you can plead that you're guilty due to mental illness. And if you're successful related to that defense, then potentially you may have a civil commitment kind of situation and what you call a best case, or whether they call it, a lot of times you hear not guilty by reason of insanity, et cetera. And so in a particular circumstance, he may be civilly committed for a unprescribed period of time unless and until doctors feel like he is okay to be released. Now, in all disclosure, based on his agreement to plead guilty, I don't know that where it actually goes in terms of the punishment side. I don't know if he actually agreed to be imprisoned for life, but that in and of itself doesn't make sense because it's not a death penalty state, and the worst penalty he could have gotten anyway would be imprisonment for life. Now, it would have been mandatory under these circumstances. But
and to be clear, there is always a possibility that if somebody is determined to be mentally ill, not criminally responsible, they're committed to a mental health facility, they could be released. They could be released back into society.
Mm-hmm. Yeah, they absolutely could. And so if you are able to be successful going down that road, then you would be there as long as doctors felt like you needed to be there. And I'm certainly not a doctor. I'm a lawyer. And sometimes I question that decision. But in any event, what I'd say is
your decision to become a lawyer, or question whether you're actually a lawyer? Because
some of both. I've got the handwriting of a doctor. I'm told that all the time. So I said, well, maybe I don't know if I wanted to do med school or anything like that. But
right.
But this theoretically could go down the road where he is evaluated a certain way, evaluated over time, and that there's potential one day for release under certain circumstances. And theoretically speaking, a sentence where you don't definitely have to always be in jail, you're civilly committed as opposed to being in a prison, and with the potential for maybe daylight one day, maybe never, but maybe one day, would be certainly better than going and doing hard time for the rest of your life.
Now, when we're looking at Minnesota law, my understanding is, and correct me if I'm wrong, if we're talking about somebody being not criminally responsible due to a mental illness, you have, this is this kind of insanity defense, right? So a mental illness made the person basically, they couldn't understand what they were doing, or they didn't know what they were doing was wrong at the time the offense was committed. It has to be at the time the offense was committed, okay? Not all the way in the past, not now, not how they're doing now. How they're doing now sometimes is a competency issue. How difficult is that in general? And as we go through this, I don't know. There are aspects to this case. I mean, if I just told you the fact pattern, I say, listen, you got a guy accused of doing this to his sister. The motivation here, because she was, pregnant? That's the alleged motivation.
Pregnant and therefore not innocent.
Yeah. tell me if there's something there. And I know it's a high bar, but tell me if there's something there.
It would seem to me to be very difficult. And so, again, going along that doctor path, is there a possibility that he is set off, a doctor may argue, because it was his sister, if he had a law-abiding past, et cetera, and this really truly came out of nowhere? Is there the idea that something was set off in him pertaining to a sister, pertaining to this related sense of honor, and that therefore there's no way this could happen with anyone else? Could a doctor do that? And or could a doctor also come out and render a decision 20 years from now, a determination 30 years from now, 40 years from now, that this person has been successfully treated from what he actually did? So it's not just a matter of, well, as long as it's not his sister getting pregnant, he's fine, but that there was something wrong here and it's been fixed. I think either of those are a tough sell under these circumstances because they're just so egregious and so terrible. And if he is pleading, what that means is whatever he's going to get for pleading is not as bad as what he could have gotten, but it's not as good as what he could have gotten if he went to trial and was successful with his mental illness defense. So it's somewhere in the middle in terms of what can happen. I'll also add quickly that sometimes you can go to trial in Minnesota and get a sentence of guilty, but be determined mentally ill and therefore actually get treatment while you're in prison. You're not civilly committed, but you actually get treatment while you're in prison.
Right, and that's different, obviously. Look, I will also say him allegedly running away, that would seem to show, you knew what you did was bad. Because look, there are crimes that I cover all the time where you would say, no one in their right mind could have done this. It's not the standard, right? I mean, I think we could look at, if I give you 100 cases of brutal murders and someone diagnosed them, and someone would say they suffer from this, they suffer from this. I mean, maybe you're right, they do suffer from mental illness, but it has to take that extra level. You had no idea what you were doing. You didn't even know what you were doing was legally right, legally wrong. And that's why it's a high bar, because everybody else would try to argue that and potentially not go to prison. So to really understand here what the defense is up against and what the prosecution is going to attack, I got to lay out the specific horrifying details that are laid out in the original criminal complaint. And this isn't just about the journals, because the complaint paints a scene of extreme methodical violence. I want to look at what police say they found inside the house. So the complaint states, quote, officers entered the residence and observed a large pool of blood on the kitchen floor, under the sink, and on the sink cabinets. Additionally, they observed a bloody saw, hatchet, and large bloody knives. As they continued moving through the house, they saw a knife on the living room floor near the staircase that led to the second level. In continuing their search, they located several dismembered body parts believed to be those of victim one. Now, Joe, I don't mean to be macabre, but if you're talking about a dismemberment like this and you're talking specific tools and maybe this took a period of time and it wasn't just one instance, one action, would that tend to help a mental health defense, or would that tend to negate it? Because again, I do wonder if it did take some time, is it tough to argue you really didn't know what was going on? You really couldn't appreciate this? But on the other hand, if it's so grotesque and so unbelievable, I don't know. I wonder if that period of time, that period of action, multiple tools, you tell me.
I would think, now again, we're in a business where two people sit on sides of the table, opposite sides of the table. One argues the world is flat, the other one argues that it's round, and nobody gets sued for malpractice. So there's a way that each side would argue. My sense is that this would not tend toward helping him. All of this deliberation, all of this plan, and going back to go forward, we got these things. This is when she comes over for dinner. Did he invite her over for dinner, et cetera? Was this all part of the plan? To me, the more of this that goes on, the more method I see. You know, you got to be kind of special in a negative way to want to kill someone anyway. Okay, so it's like we're arguing, is someone crazy or not for killing someone? If you walked up to me, Jesse, and said, I'm going to kill somebody today, what's the first thing I'd say? I'd say, man, you're crazy. You can't do that. And so it's relative. The whole idea that the fact that someone isn't all there where they're crazy enough to kill someone and not crazy in the medical or the psychological sense, but thoughtful enough to actually do something like this at all. The idea that they have done it so methodically, et cetera, is not going to automatically land them in the place where they say, oh, this person is clinically crazy and therefore they need to be civilly committed. No, this person was crazed. It ought to be first degree. It ought to be second degree, whatever the case may be. That's not going to absolve them. And these facts and details don't help them.
Mm-hmm. Now, the complaint also details what investigators say they found that speaks to the motive, which we've been talking about. And it's in allegedly his own handwriting. It states, in his writings, defendant wrote that he was angry victim one was pregnant and no longer innocent. Quote, no longer innocent. Joe, how does that affect the analysis?
I don't think that helps him at all, because most of the time when I'm a jury and I'm dealing with a case, I'm dealing with a murder, a lot of jurisdictions, you don't necessarily need a motive, but it helps. It puts things together. It puts the pieces in place. The idea that, of course, the defense is going to argue something else. And I would think that they would add some kind of triggering event even while they're there, right? At dinner, to create a second degree possibility or to create a mental illness possibility. But the idea that he's letting us know why he's going to do what he's going to do, just as much as the defense might think that it speaks to mental illness, I think that it speaks to plan and deliberation. And so therefore, he's going to have just as much of a problem because he laid out what he was going to do.
Right. And by the way, this is a battle of experts, right? You would have a defense expert, mental health expert, a prosecution mental health expert. Do they both examine him and they come with their own conclusions? And I guess a lot of people would also be wondering, how do you find somebody that would agree with your position? Because then it looks suspicious. What do you put an ad? Hey, we're looking to find this guy not guilty by reason of insanity. Anybody look at this? I mean, how do you find the expert that's going to, help your case?
Folks that are in this business will know both people that might be more defense or prosecution inclined, or understand their expert or their potential expert who may do both prosecution and defense. And it's good to be able to say your expert does prosecution and defense. It's even better to be able to say, if I'm the defense, to have somebody that normally does prosecution, or vice versa, right? Because it's almost like this is more off the beaten path for them to take an exception to their own rule. It is full and free and fair game for the defense to rail on the prosecution's expert and say, well, you do all prosecutions. You've done 20 cases with this attorney, haven't you? And vice versa, right? So you know who the folks are in the business. Sometimes on the civil side, in my world, we may talk to an expert just to take them out of the running to represent the other person as well. So you have a sense for where your phone calls start, even if you're not sure of where they end on who it is you end up arriving on.
Now I want to follow what happened next. So after the Ring camera call, police, they find Ball. He is apparently found in the backyard of a neighboring house. According to the complaint, he was, quote, covered in blood on his head, shirt, arms, legs, and pants. He had apparently a self-inflicted knife wound to his neck. But here's a key line for the mental state argument. So the complaint states that Ball was able to communicate with officers and accurately told them the date, time, and name of the current president. I find that interesting. So, Joe, how important is that? Could someone know all those details and still be mentally ill? Like they might know, yeah, today is Tuesday, president is Donald Trump, I work here, I'm 44 years old, whatever it is, and then say, yeah, but I saw an alien spacecraft coming down. I mean, how important is that to the analysis?
I would say that it is and it isn't important, right? I mean, if someone decided that, I'm going to play this game of mental illness, they could also say that they thought the president was Jimmy Carter. There's nothing that keeps them from saying that, right? So the fact that he said what he was clear about, can go both ways, just like everything else can. It certainly doesn't allow the defense to state, well, he didn't even know what day and time it was. He's in another space. He's in another universe. There's clear indications. For whatever reason, not only was, and this is the part that I think that I use if I'm the prosecution, not only was he clear about the days, the times, the place, kind of where he is, but he was okay with being clear about it. And so, therefore, Here's a guy that he says, look, I'm just really mad. I'm really angry. It comes through in what he wrote, etc. And he had no second thoughts about letting them know that he was fully cognizant about what was going on. He understands his surroundings. He understands what day and time he's in, etc. So I don't think that that's something that helps the defense, even though they can still use it to say that doesn't mean that the person's not mentally ill. There are plenty of mentally ill people that know what day it is and know who president is.
What about the apparent self-inflicted injury?
Similar to a lot of other people that have killed other folks and then attempted to kill themselves afterward. It's still a two-sided coin to my mind. The prosecution is going to say, well, there's consciousness of guilt. He doesn't want to be here. He knows that there's no way out in regard to what it is that he's totally done. And maybe he's one of these guys that just says she has to suffer the ultimate sacrifice and for honor reason or whatever it is, like almost like an honor killing. And if I have to die too because I don't want to accept the consequences related to that or because the police isn't going to understand, then so be it. The prosecution can use it to do that. And the defense can use it to say, well, that it's part of this larger story of mental illness, how one could potentially see this coming, particularly if it shows up in his past. And that's the part that we're not as clear about.
Putting aside the legality here, if this now advances to another trial, even though he's admitting guilt, what impact does this have on the family? From your perspective, what is the emotional cost for this next phase for a family who has already gone through so much with a case like this?
It's a double whammy because you've got one family member killing another. It's one thing, it's hard enough, and something separately that I dealt with, losing a family member violently, right? It's another thing when one family member has killed another family member, and I don't remember whether her parents are still around. They were at that time. So now the parent has the loss of a child physically, and for all intents and purposes, the loss of two children, because a life will never be the same for one or for the other, a potential grandchild, etc. So it's beyond grueling. I am certain that as a parent, it's something that you never get over. They might spend a whole lot of time second guessing themselves. How could this happen? Particularly if it's not like culturally related or things like that. There are some cultures where this type of thing happens, God forbid, etc. It came out of nowhere for the parents. This is not somebody getting hit by a car. This is one child killing and cutting up the other. And so you just don't get over it. What do you say? There are no words. How do you get past that? I mean, and you don't. And how do you keep living? I think it's very hard.
It is very hard. It is difficult to even imagine. It was difficult to even think about this headline when we decided to cover this story. Joe, we're going to talk a little bit more about the victim in this case. We're going to put an element to who she was in a minute. I'm just going to thank you right here. Thank you so much for taking the time to explain the legal aspect of it, as you always do. And despite what you may think about yourself, terrific lawyer. Yeah, so, thanks so much, Joe Richardson. Appreciate it.
I got a big case coming up next week. Listen, I'm going to show it to this judge if he'll look, and maybe we can hang in there. Thank you, Jesse.
Joe, appreciate it. Now, again, after a discussion like this, it is important, it is necessary to return to who was lost here in this case, in this tragedy. Bethany Israel, 30 years old. From her obituary and the words of those who loved her, they paint a clear portrait of how special this person was. She was a dedicated teacher, a passionate volleyball coach. Her family wrote that her presence on the court was, quote, nothing short of angelic, always smiling, encouraging her teammates, and striving for excellence. She met her husband Josh at an Apple Valley Volleyball Open gym. They eloped in Jamaica in 2021. They shared a love of traveling, for card games, for dancing. And as her obituary gently notes, quote, Bethany believed she wasn't particularly skilled at it. Now, they were expecting their first child, a son. I mentioned before, they named him Levi. Her family describes her as the embodiment of love. Quote, she never spoke negatively, always sought to help others, and wore a perpetual smile. Her light touched the kids she coached, the friends she played with, and even the newcomers she welcomed onto the court. In the wake of this unimaginable loss, a GoFundMe has been set up. Its description doesn't focus on the horror of what happened to her, but on the warmth of her life. It reads, Bethany was not only a cherished wife, daughter, sister, and an expectant mother, but also a beloved figure. Her radiant spirit and unwavering kindness touched the lives of all who had the privilege of knowing her. And it concludes, as a beacon of warmth and generosity, Bethany's absence leaves a void that cannot be filled. And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. We're also up on NBC's Peacock as well. If you want to follow me, check me out at X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. Until next time, stay safe, everybody. If you've been following the savage killings of Spencer and Monique Tepe out in Ohio, you know there has not been a ton of information about the investigation, about the evidence. However, there is now new warrant paperwork that has been unsealed, and we just learned new details about what authorities may have been looking for and possibly found as Monique's ex-husband, Michael McKee, stands accused of this brutal double homicide. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Hey, real quick, I got some really exciting news that I want to share with you, okay? So we have spent so much time together here at Law and Crime, obsessing over every wild twist and late night case, but we wanted to find a way to bring you even closer to the action. And that is why we are finally launching Law and Crime Plus. This is your new go-to spot for thousands of hours of commercial-free episodes and exclusive case files where you can dive into the evidence yourself. We really built this for the community of people who stay up late analyzing every detail while waiting for a verdict. So it's just as much your space as it is ours. Go ahead, download the app, check out the features, let us know what you think. You can head on over to lawandcrimeplus.com today to snag our limited time deal for just $3.99 a month or $40.99 for the year. One of the biggest questions we have had in the Tepe murder case is what exactly is the evidence? We know the victims: Spencer Tepe, 37-year-old dentist, his wife, 39-year-old Monique Tepe, parents to 2 children. We know it was a brutal crime. Authorities say they were gunned down in cold blood on December 30th inside their home in Ohio. This is in Wineland Park, the 1400 block of North 4th Street. Authorities say this happened at 3:52 a.m. Authorities indicating that Spencer was shot 7 times, Monique 9. We are talking a full magazine of bullets, and the couple's 2 young children were inside the home when this happened, but thankfully, they weren't physically harmed. Now, the couple were reportedly declared dead hours after the shooting at 10:11 a.m. Apparently, this came about after calls came in, one about how presumably Spencer was not showing up for work. There was a call about someone seeing a body inside the house from outside the home. And we know the defendant. Authorities say the accused killer is Monique's ex-husband, 39-year-old vascular surgeon Michael McKee. They had been divorced since 2017, nearly a decade. And we know the accusations. Authorities claim McKee was living 7 hours away in Rockford, Illinois, when he allegedly drove all the way to the Tepe home in Ohio and shot them point blank. He is even accused of using a silencer or a noise suppression apparatus. He was arrested in Rockford on January 10th, faces 4 counts of aggravated murder and aggravated burglary. He has pleaded not guilty. He's in the Franklin County Jail in Ohio right now, no bond. But what we didn't have was a lot of the actual evidence, the concrete evidence in this case. But now we talk about the new development. There is newly unsealed warrant paperwork that has just provided us more details that we want to go through. And we want to talk about the relevance. We want to talk about what they may have found, what the defense can do to fight back. And to be clear, as I go through this and I go through the accusations, Michael McKee is innocent until proven guilty, okay? He has not been convicted. To discuss all this, I want to welcome on Ohio prosecutor, former Deputy Attorney General Mark Weaver, friend of the show. Mark, always happy to see you. It's been a minute. I have to ask you about these new details. First, before we even get into it, to set the stage, when we talk about a search warrant, and reportedly under Ohio law, my understanding is a search warrant can be unsealed after 90 days. So now we're getting more information. According to the Columbus Dispatch, after the Tepes were found, police had to then go to a judge to sign off on the search warrant, which happened, I believe, at 11:36 a.m., so relatively shortly after the bodies were discovered. Is all that standard? Why do they even need a warrant? Do they say, hey, look, there's a crime, there's 2 dead bodies, why do we even need a warrant? We can immediately collect the evidence.
When a crime scene is secure and there's not a particular rush, now obviously trying to find the killer is one kind of a rush, A lot of prosecutors want to make sure they have a belt and suspenders approach. So under the Fourth Amendment, there was a requirement for a search warrant. There are several exceptions to the search warrant rule, but there's nothing better than having a search warrant from the judge. So when there's time, we secure the scene, we get a search warrant. Sometimes we go back for an additional search warrant if the first warrant didn't cover some things that we think it should have covered.
And by the way, just taking a step back, am I correct that under Ohio law, the search warrant can be unsealed after 90 days? And why that time period? And is this problematic for prosecutors that this information is getting out to the public at this point before there's a trial?
You know, you are correct. That's the way it works. It's problematic in that there's been so much pretrial publicity about this case, and there's been not enough information to feed the desires of the public to know what happened. As more details come out, you could see the defense, and I know the defense attorney, Diane Menashe, she's very good. She doesn't have a great case, so she's got to find a way to protect her client. That could include asking for a change of venue. It could have include any sort of pretrial publicity motions that might limit the ability of the public to learn more.
I definitely want to talk about her. I want to talk about what the defense strategy here is, but I have to get into the details of this affidavit. Okay, so we have this affidavit from police that was in support of the search warrant, provides more information, right? It shows why we needed the warrant to look for evidence. And it indicates that investigators collected 29 pieces of evidence, which could include items that were packed together, multiple swabs of potential blood and or DNA evidence, and 15 sets of fingerprints, and that there were more than 400 photographs that were taken. I want to take this piece by piece. So Mark, when you look at this, let's first start here. Where did they get the blood, the DNA, the fingerprints? They had to be at specific relevant locations in the home, right?
Sure, the goal is to find as much as you can in the part of the house where you think the murders occurred. For example, we're now pretty sure that where the children were, there was never any crime happening there, and so that's less of less of a focus of our interest, more where the bodies were or where we think the intrusion was. In any typical house, there's DNA everywhere. Now that we have touch DNA ability, everybody's house has hundreds of different sets of touch DNA in all sorts of places. Blood obviously is a little different situation. Most of us don't have blood in our house. But crime scene investigators, particularly in a heinous case like this, they want to overfind. They want to over stress what they need to collect because we don't know what's going to come up at trial.
And what do you think could come from that? What kind of testing do they do? Is it complicated by the fact that this is in a home, right? You tell me, I mean, what kind of tests are conducted on this kind of evidence, and what do you think can come from it?
Well, DNA analysts will tell us, first of all, almost immediately they can say, is this male or female DNA? And if they have a sample of the suspect's DNA, they can try to do a match. It's not like it is on some TV shows, though. You have to have a good amount. I just recently prosecuted a child rape case, and one of the indicators in that case was we could tell that the DNA was from a male, but we couldn't tell what male it was from. So a lot of this has to depend on the quality of the sample and how much of the sample was taken.
Yeah, and if they find like at least one fingerprint of Mr. McKee in that home, is that game over? Or again, you know, I'm going to talk about this a little bit later, but there was an allegation that he had been at that home before, right? I think December 6th. If they find a fingerprint there, is that the end of the game for him?
It's certainly the beginning of the end of the game. There's no reason for him to be in the house, in the private sections of the house, even if he had been there previously. If his fingerprint is near the bodies in one of the bedrooms, they're going to have to come up with a theory for that. More typically, they're going to push to take, to try to make a deal in some case and try to reduce the charges, get some sort of outcome, because fighting this at trial will be very difficult. From what we've heard so far about the evidence, it is beginning to amass not just one piece of evidence, but several key inculpatory pieces of evidence.
Why 400 photographs? What are 400 photographs taken, and how does that help the prosecution? How does that help the investigation?
Different crime scene technicians do this differently. And so some of them will, take example, let's say there's a cup near a body. You take it from every different angle. You take the photo from above, you take it from the side where the handle is, you take it from the other side, you take where it's resting. So that's 4 images just to capture one cup. You never know at trial what some defense lawyer might suggest to the jury and say, why didn't they take this one angle of the cup? What are they doing there? Jurors can get suspicious when defense lawyers, scatter seeds like that, seeds of doubt. So crime scene investigators, depending on their outlook, will often go over the top with what's necessary rather than later be accused of willingly not taking some image.
When they talk about items packed together, what do they mean?
Well, that could be anything. That could be, for example, a box that has several items in it. It could be a stack of paper that put together, something that's clipped together. That's a general description. It's hard to say. But for example, if the murderer interacted with that something packed together, jurors were going to want to know, was it originally packed together? Did the murderer put it together? Were these items elsewhere previous to the crimes occurring? Once again, the more photos and images you have, then as a prosecutor, I can go through and decide which of these images I'm going to admit into evidence. It won't be all of them. It'll be the ones that really help tell the story.
I want to also highlight something else. So according to 10 WBNS, the warrant indicates that authorities were also looking for firearms, shell casings, and home security footage. Talk to us about that.
Well, we all know now that home security footage is ubiquitous, whether it's doorbell cameras or whether it's people who put up cameras outside their house, or in some cases inside their house. So that footage is important, not just from the day of the crime, but from days previous to the crime to see if anybody was scouting or staking out the house to find out how to get in there. With respect to the other things they're finding, obviously we want to know about any guns or any casings, both in the home of the McKee, the suspect, as well as the home where the crime occurred.
Why is there not more information in this warrant? I have more pieces I want to get into, but why is there not more information, more details about this? I mentioned at the top there's seems to be a lack of understanding all the evidence they have against him. I'll talk about more of the evidence in a minute, but why is there not more details of this investigation in the affidavit? As far as we could see, we didn't get a copy of the actual one. We're looking at reporting based on it. Why is that the case?
Well, police get a sense for which judges want how much information in the search warrant affidavit before the judge will sign the search warrant. Also, in a high-profile case, some judges don't need to know a lot. They know there's a problem. They know there's going to be a lot of scrutiny on them, and they're just quick to sign. They don't want to be criticized for not having issued a search warrant. So it's a officer-by-officer determination. It's a crime-by-crime determination, and a judge-by-judge determination.
Now, also, according to the Columbia Dispatch, this is kind of all the material that has been sent over by prosecutors to Mr. McKee's attorney, Diane Menashe. You mentioned her before. We've interviewed before. We covered her, by the way, on a previous sidebar in light of her coming onto this case. We talked about her previous cases, her defense strategy, her win record in high-profile criminal cases. She's an excellent attorney. I encourage everybody to check that episode out if you want to learn a little bit more. But here, according to the Dispatch, this is what was apparently sent over to her. So multiple search warrants from Ohio and Illinois, firearms experts reports, comparison images and evidence images, more than 4,000 media items, including photo and video evidence, crime scene diagrams and scans, more than 250 video files of surveillance-related footage from the Rockford Hospital where McKee had worked. And by the way, we, the public, can't see all this evidence at this point in time, but I do want to talk about it. Mark, search warrants. Is Diane Menashe going to go through them and see if they're defective, if they're beyond the scope, if they were supported by false information? Talk to us about how a defense attorney attacks a search warrant, and if it's successful, what should happen?
Well, there will be a lot of pretrial motions filed because particularly when there's a significant amount of evidence, the job of a defense attorney is to try to find something wrong in the process, to try to convince a judge that law enforcement or the prosecutors have somehow cut a corner, broken a rule, done something they shouldn't have done. We saw this most recently and most infamously in the Alec Baldwin case. Everybody knows Alec Baldwin shot and killed that woman. There's no doubt about that, but the case was dismissed. Not because he wasn't guilty, but because there was allegedly a problem with how the prosecution had handled the case and the judge dismissed it. So particularly in those cases where the evidence is strong, defense lawyers focus a lot in the pretrial motion practice on mistakes made. Now, you talked about the amount of evidence that was given over to the defense. A cynic would say that's the strategy of here's the haystack, go find your needle. Someone else might say, well, no, I don't want to be accused of a Brady violation. Brady versus Maryland, the U.S. Supreme Court case that said you have to give over exculpatory evidence as a prosecutor. So someone else might say, no, I'm going to give you everything. We're going to play our cards open and up on the table. Either way, it's a ton of work, and hundreds and thousands of man hours will be spent reviewing this evidence and preparing this defense.
I think the firearms expert reports are very interesting because I'm curious what we can expect there, because my understanding is, okay, authorities allegedly recovered a weapon from McKee's home out in Illinois that they believe is linked to the Tepe killings, that this is based on preliminary ballistic testing. So we're talking potentially the murder weapon, right? What is that testing? What is that testing? I will tell you, let me just add to a list. According to Columbus Division of Police Chief Elaine Bryant, they use national ballistics data through the National Integrated Ballistic Information Network, or NIBIN. So what exactly would these reports say? What is preliminary testing?
Well, many rounds, which is what we call the piece of lead that's inside a bullet, many rounds and the cartridges have their own signature that's unique to the gun that goes through them. They're not registered. Not every bullet has a serial number on it, for example. But depending on the kind of gun it comes out of, it might leave a signature as it goes through the barrel based on the unique metal factors of the inside of that barrel. Having said that, we know this in the Charlie Kirk case right now, where there's a discussion about whether or not the bullet can be matched to the rifle. I worked on a case years ago, officer-involved shooting, where several officers had to fire their weapons at the same moment at a suspect who was pointing a gun. And when we took those bullets to get analyzed, they were all Glocks in this instance. The expert told us that the nature of these guns, you couldn't tell which gun fired which bullet. So sometimes we know it can do a direct match. Sometimes we can't because of the nature of the inside of the barrel and the way that the firearm ejects the bullet.
And it could be, if a case only rested on that, and you can strike, you can raise a little bit of reasonable doubt in terms of the murder weapon, in terms of who fired it, or in terms of, if it's the actual weapon, that could be, end a case. But when you couple that with the other evidence in this case, it's just a piece of the puzzle, right? And I want to talk about that a little more, because when I'm saying the 250 video files of surveillance-related footage from the Rockford Hospital where McKee worked was sent over to Diane Menashe, before I even get into the other evidence, and I'll get into that cell phone and the car, what are they looking for there? Why is that relevant to the case where he worked?
Trying to build a pattern of where the defendant was in the days and weeks before the crime, when he arrived, by what direction, and then looking to see if that pattern has changed. You also might want to see what he's wearing. Famously from the O.J. Simpson case, the civil case, the kind of shoes that he used to commit that murder were found in a photo of him at a charitable event years earlier, a very unusual set of shoes that wasn't commonly sold. So by looking at a photo of him at a charity event months or years before the murder, investigators for the civil attorneys were able to identify that set of shoes as the one that was used by the murderer the night of the murder. So similar, you're looking for patterns, times, clothes, things he may or may not carry with them. You never know what could be a clue, both for the defense and for the prosecution.
And this is where I want to get into the other evidence, okay? Because there's some more evidence that we've at least learned over the course of this story. For instance, the Columbus Dispatch reports that McKee's cell phone showed no activity for 17 hours, or allegedly showed no activity for 17 hours, and it was only picked up again when someone would be coming back to Rockford. And they claim that that data shows McKee was near the Tepe home, including for several hours on December 6th. But this is when the couple was out of town. NBC even reporting there was security video showing him going into the home. Mark, talk to me about that.
Yeah, this is one of the most troubling things for the defense. There's no good reason for him to be 3 states east at the home of his ex-wife. He can be up to no good. And now someone might say, well, it's not illegal to do that. We're not suggesting it's illegal to do that. We're suggesting it indicates you still have a very dangerous interest in your ex-wife and her new husband. Anybody with a lick of sense knows that your cell phone tracks you where you go. And as a result, anybody with a lick of sense who wants to not be tracked will somehow disable their cell phone. They'll turn it off. They'll remove the battery. They'll do something that would stop any signal from being put out to a cell tower. And so that's likely what happened here. If he is prepared, think about this. This is not a crime of passion. A crime of passion is when you come upon something and you act impulsively. When you live in Illinois and your ex-wife is in Ohio, just the time it takes to drive there gives you plenty of time for what the law calls prior calculation and design. As part of a criminal's prior calculation and design, they think about how can I avoid detection, shutting down my cell phone, putting it in a special bag where the signal doesn't come out. Whichever way he disabled it, that's likely what happened.
It's similar to Koberger when they said that he turned his phone off at the key time of the killings, but at least he had some sort of, I don't know, I don't think it was going to work, but he was like, oh, he went to school relatively nearby. He might drive in that area. If they can establish through cell phone data or through surveillance that McKee is there, it doesn't make sense. That's, I think, going to be quite problematic for Diane Menashe, although I wonder, can you strike at the actual data? Is that ever effective? You say, hey, this is not, you can't look at the cell phone data, it's wonky. You can't look at the surveillance data, it's wonky. Does that work?
It typically does not work by matter of suppression, because you'd have to prove a Fourth Amendment violation at a suppression hearing. More typically what they'll do is they'll try to attack the foundation or the authenticity of it. At trial, a prosecutor has the burden of submitting evidence to the judge and saying, Judge, here's the foundation for the evidence. Here's the authentication for this evidence. Please admit it into the case so that the jury can consider it. That's the part where the defense will attack it. Somehow say there's not a proper foundation, it's not properly authenticated. They're going to try to keep it from getting in, either at a pretrial motion in what's called a motion in limine to limit evidence into the trial, or during trial when they put the person on the stand who collected the evidence and by way of cross-examination and impeachment of the process of assembling that cell phone information.
And now I got to go to this other key piece of evidence. This is a big one. So authorities say they clocked a car near the Tepe's home before the killings. And then this car allegedly left after the killings, that it was seen on camera at least one other time in that area. And they reportedly traced it back to McKee and back to Rockford. And they claim that McKee allegedly used at least 2 license plates on this silver SUV, including one stolen Ohio plate and an Arizona plate. And when they apparently found the car, it reportedly had the Arizona plate, and there was evidence that a sticker had been, quote, hastily removed. Mark, A, how do they know this? What evidence would be used at trial to support this? And B, how problematic is that for the defense?
Yeah, this might be one of the strongest pieces of evidence I've seen in this case. In 49 states, including Ohio, there are flock cameras, that's the name of the company, that tracks license plates and allows police officers to find stolen cars, people who have a warrant for them, even suspended tags. And so as we all drive around streets, and in most states, these cameras capture our license plate. And they're actually programmed to look specifically at license plates and check them against outstanding warrants. That's likely where it came from. It's entirely possible it also came from security cam from nearby homes as well. But the flock cameras are ubiquitous around big cities like Columbus. So you're gonna hit them several times as you traverse through the city. Again, somebody who's smart knows this. You can't be a doctor and not be smart, right? So somebody who's smart knows this And as a result, he's been taking steps to try to evade that it's him. Stealing a license plate is an obvious one. None of us secures our license plate. All you need is a screwdriver to remove it. And then tearing off stickers that might indicate, what county it's from. For example, in Ohio, every license plate has a sticker that indicates what county it's from. That might be something he did as well.
But Mark, there's so much we don't know in this case. I'll give you an example. They say that these killings happened at 3:52 a.m. How do authorities know that?
Well, some of it could be a doctor could not get you an autopsy doctor, a forensic specialist could not get you to the exact moment, but other devices, electronic and otherwise in the house that may have been involved might do that. Certainly people, those of us who wear smartwatches know that, for example, my smartwatch is constantly monitoring my heart rate and things that are happening in my body, whether I'm, being healthy or not. So that creates a whole new set of evidence that we didn't have as recently as 15 years ago that can tell us what's going on in a person's body based on the watch they're wearing or other device.
Yep, that's a good point. But again, there's just so much we don't have that I would like a clear explanation. But again, that's the purpose of a trial. Motive hasn't been laid out, right? Not necessarily. And to be clear, it doesn't necessarily even have to be shown or be proven. It's not an element of the charges. It does help to fill in the pieces. It does help to tell the story for a jury. And one of the things that's come up, and NBC has highlighted this, they reported it, that there is this probable cause affidavit that indicates that a person told authorities that McKee had allegedly threatened Monique, saying he could, quote, kill her at any time and would find her and buy the house right next to her. That there was also an alleged statement that she will always be his wife. And allegedly Monique told the witness about this. I don't know if there are hearsay issues here, but Mark, it does. Yeah, I mean, first of all, you tell me if that would be like a hearsay issue, but also, is this the kind of evidence that would help? I mean, is this the kind of evidence that would establish how somebody, which it makes this case so bizarre, divorced for so many years out of nowhere, just comes up and allegedly kills her and her husband?
Let's respond to your last question. This is the kind of evidence that would help the jury if we can get it in. I'll address the hearsay question in a moment. As you mentioned, we don't have to prove a motive, but juries are desperate for a motive, particularly in a case with such serious penalties as this. So jurors would like to have a theory. It gives them great comfort to know that, I can see why he would have done this. That means probably he did it. So if this comes in, it's powerful, powerful motive evidence, even though it's not required to be shown. Now, with respect to hearsay is an out-of-court statement offered to prove its own truth. You put John on the stand. If John says, Mrs. Tepe told me this once, that's hearsay. That is, there's no exception to the hearsay rule for that. But if John gets on and says, no, the defendant told me once, that is an exception to the hearsay rule. That's not hearsay what the defendant has said, even though it's an out-of-court statement offered to prove its own truth. There's a specific exclusion for the exception rule that allows that to come in. So it's going to depend on who is the person saying this statement and where that person heard it from.
Do you think this is relevant? Because we haven't had a chance to talk about it, that there was reporting that 3 months before the shootings, McKee was apparently being sued for medical malpractice. People magazine saying a friend of Monique said he thought she could not live without him, that she needed him. So for her to thrive in her new marriage, that just destroyed his fragile little ego. I mean, this is somebody's opinion, but how much of what's going on in McKee's life, or was allegedly happening in McKee's life, is going to play a role in this trial?
There's an evidence rule that judges have to consider that says that evidence that is more prejudicial than probative has to be excluded. Prejudicial means it's going to inflame the passions of the jurors. Probative means it gives the jury's insight into the crime. And so there's a balancing test. It's a very common exception you see at trial. Judge, that's more prejudicial than probative. That's going to mislead the jury. It's going to get them down a path that's not probative as to what the elements of this case are. So I would be surprised if the judge would not be asked to rule on that by defense counsel. I think that would come up. If that evidence were offered, either at pretrial, Diane Menashe and her team would seek to exclude that testimony, or during the trial itself.
The closed-door status conference is being held on April 13th, where I imagine they are just going to try to maybe set future dates for, I don't know, motions or hearings. So we'll see what happens. But again, it's closed door. We're not going to get a ton of information. But I will just end on this point. Look, it's a very high-profile case. There are a lot of people invested in this. Their deaths have shaken that community, their friends, their family. It is awful. To just give you a sense about this, NBC reported that the Tepes relatives had said that this couple shared a, quote, beautiful, strong, and deeply happy relationship, that the family is heartbroken. Quote, while no outcome can ever undo this loss, our family is committed to seeing this tragedy fully and fairly brought to justice and to honoring Spencer and Monique by protecting the future of the children they love so deeply. So we talk a lot about the evidence, but that's the human point of it. Mark Weaver, thanks for taking the time. Really appreciate it.
Thank you, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. I'll see you next time, everybody.
अल्फ अल्लाह की ज़ात तू ऐ झोर सदके जेड़ो कुल कायनात चलाण आलो अल्फ अल्लाह की ज़ात तू झोर सदके जेड़ो कुल कायनात चलाण आलो हुक्म उस गे बाजना पतर अल्लाह ओ तेरो मेरो वजूद बनाण आलो 18,000 मखलूक गो ऐ मालिक सुनो रब सुनो जमीन आसमान आलो अर्श फर्श लो कलम महफूज कुर्सी जिया जून ना रिज़क खिलाण आलो दाल दुखांगी गल सो नौरे तमना एक बच्ची मासूम रोलाओ गई है दाल दुखांगी गल सो नौरे तमना एक बच्ची मासूम रोलाओ गई है ओ उसकी मारे गुलनाज है बहुत दुखिया ये मारा सीना माँ बर छिलाओ गई है नाओ बच्ची गो अफसा में मूद सोनो रोग उमरा गो सुनी लाओ गई है ओ जिला पुणछ गिरा शिंदरा सोनो ऐ दुखिया दिलाना अफजारो लाओ गई है दाल दर्द जो दयागा ऐ बोते ओ खाए पर बचागी नारे जो दई ओवे दाल दर्द जो दयागा ऐ बोते ओ खाए पर बचागी नारे जो दई होवे ओ माना सबर करार फिर नहीं रहा तो ए दख्ते जिगर की जद जो दई होवे ते बाप उसको मैं मुँह दियो हुसैन दुखिया अफसा जही बची सिने लाई होवे ओ दुख मुझ जावेद माँ बाप नावे ओ बचा किसे ही नारे जो दई होवे तेरे हो रब गा कर तमाम होए आस्तारा अप्रैल ना खुशी भरपूर होई रे हो रब गा कर तमाम होए आस्तारा अप्रैल ना खुशी भरपूर होई ओ अल्लाह पाक ने दिती एक बच्चियों सोनी ऐ गुनाह करांगी अर्ज मंजूर होई दिन माँ दाखिल रही महारात ऐ 10 बजे ऑपरेशन होयो ते टेंशन दूर होई ओ दीती खबर फिर आनी उन डॉक्टरां ने होगी बची पर बड़ी कमजोरी होई सलाह दीती वीर डॉक्टर है कमजोर बची ले गए बीच मशीन रखाओ दीती ऐ सलाह दीती डॉक्टर है कमजोर बची ले गए बीच मशीन रखाओ दीती 18-19 तक रखी पुणछ अंदर और पर इकी नर जोरी कराओ दीती ऐ रात 9 बजे मामू ऐ नानी दोए गड्डी तरफ जोरी चलाओ दीती ओ मासा देरी ना लाई ले चल गया ओ 12 बजे जोरी पहुंचाओ दीती किसना चैन सकून फिरे आई उस दिन तो रास्ता बिच डाडा परेशान होया आई किसना चैन सकून फिरे आई उस दिन तो रास्ता बिच डाडा परेशान होया रात 12 बजे जोरी पुजया कि जल्दी डॉक्टरां कोल रवान होया ऐ डॉक्टर नब्ज तके मुतू ये बोल न सके असली राज तू बे वो हैरान होया ओ अमानत रब की है तम सबर करियो ए आपसा बची गारू वे रवानी होया किसना होश रे ओ सुनी ये खबर जिस दम आया है आप जायमना छोड़ गई है ऐ किसना होश रे ओ सुनी ये खबर जिस दम आया है आप जायमना छोड़ गई है ये एम्बुलेंस करी वापस पुणच चलना मारी किस्मत अज मुकरे मोड़ गई है आई गुल नाज वाणी अरे मान बाकी मेरी खुशी ना किंगा तू रोड़ गई है दाखिल बीच अस्पताल थी पुणछ अंदर ये मांगुल नाज गो दिल क्यों तोड़ गई है अप्रैल बईना सुबह गए आई 5 बजे वतन शींदरा पुजे आयान सदके अप्रैल बईना सुबह गए 5 बजे वतन शींदरा पुजे आयान सदके माना 10 बजे एम्बुलेंस आने तेरा तकन गाया अफजायर मान सदके ते कितना दुख था महंगा ऐ काल जामा जाने वाया रब रहमान सदके और वे बाप महमूद परवेज नानी नाले रोवे सजाद यवान सदके कफन दफन गो वेलो हुणे यार के ओ इना दुकाना हुण मीटौरे किसरा कफन दफन गो वेलो हुणे हार के ओ इना दुकाना हुण मीटौरे किसरा ओ जीता मांगे बचा गो टूर जानो इस शेर बर कलम चनो किसरा ते अच्छा रब वाले हुणे आई छोड़ गई है तीना सिना नालू हुण लो किसरा सबर या तो नी दिल मां याद तेरी रोता दिलाना चुप करूं किसरा फिया मान इना दुखाने हई मुकणो नी 4 बजे रे आपका दफनाओ छोड़ी हई फिया मान इना दुखाने हई मुकणो नी 4 बजे रे आपका दफनाओ छोड़ी वतन पुणछ गिरा शींदरा अंदर ओ सोनी निकी जी कबर बनाओ छोड़ी सबर करियो महमूद गुल नाज दोए मानत रब गी रब ने छुपाओ छोड़ी ओए पिया मान जावे तू इजाजत ले ले जख्म मोड़ी भी क्यों रे दुखाओ छोड़ी